Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, good evening. We are here for a workshop with District Attorney Andrew Robinson. I believe he has a PowerPoint for us, and we will just turn it over to you.
Well, thank you. That's incredibly efficient. Does this PowerPoint presentation show up on any of the other screens?
Will, yes.
And throughout this presentation, you're going to learn my mastery of PowerPoint. Pretty much to take advantage of any templates they put in front of me. And you may recall the reason why I asked for an opportunity to come in and talk to you folks was I was concerned that you were having questions posed from residents here in Lewiston, that you were being placed in an impossible position of talking about what the DA's office is doing and how we do what we're doing. And had offered, if there was an opportunity, to come in and talk about the work we do and why we make the decisions, that we'd be happy to show up. And so I appreciate you scheduling us for this evening. The first thing I wanted to talk about is sort of a broad picture, and then I'm going to sort of narrow it down and hone in primarily on Lewiston, and then obviously some of the issues surrounding the work that we do in the Lewiston area. But the one thing that I'm not sure everybody understands is that the district attorney's office is District 3, and that encompasses Androscoggin, Franklin, and Oxford counties. And so we have an office here in Lewiston. We work in the Lewiston District Court in the Androscoggin County Superior Court, but I also have an office in Farmington, an office in South Paris, and in Oxford County we have Rumford, as well as the Bridgeton Court that we share. So we cover a pretty large amount of territory. Here in Androscoggin County, we work with all of the law enforcement agencies. So you can, I listed them for you, but you can see all the different agencies that submit the reports to our office, where we review them and make determinations on whether or not criminal charges will be brought. In our office, we handle almost all cases, starting at traffic tickets, because we handle traffic court with the law enforcement agencies, all the way up to attempted murder. There are some cases that we don't prosecute, and I'm not sure everybody understands that. I mean, I think everybody knows the AG's office does the homicide cases, but it's also the AG's office that does the felony drug cases, welfare fraud, and tax cases. So primarily, the Attorney General handles all of those cases. If we're asked to provide assistance, we always do. We do a lot of covering for them. And sometimes when there's spillover or too many cases, they'll ask us to help by prosecuting them. But for the most part, the AG's office handles those matters. The total number of cases for all three counties for our office is 8,092. This is based on the reports from the court system. So it's a pretty conservative number because it doesn't include all of the matters that are submitted to the office where we don't submit something to court. This is simply the criminal complaints that are filed and the probation violations, as well as some civil violations. Total number of court filings in Androscoggin County is 5,382. And then from Lewiston PD, according to our JustWare system, which is our case management system, we received 1,676 cases during this same time period, which is the fiscal year of 2018. Oh, sorry. I have a hard time seeing now. Thanks. Is this better?
It's for the TV, so I think it will be better. We'll
Should I ask the TV? Okay. And so with those numbers, I thought I'd talk about some of the challenges that we have to contend with in our office. The first is that the amount of resources we have as far as personnel are concerned. The standards that most people cite to suggest that there should be either 150 felony cases or 400 misdemeanor cases per year for a prosecutor. Androscoggin County has 9.5 prosecutors in the office to handle the 5,382 cases. So doing the math, you can see that it's 566 cases per prosecutor. Now again, this is specifically on cases that are actually submitted to court. It doesn't include the appeals, it doesn't include post-conviction reviews, it doesn't include all of the matters that are submitted for review that we don't submit complaints on. So it's actually a much higher number, but I thought in order to give a grasp on solid numbers that we can all look to and find together, I would just go with the court submission, the court's numbers from its report. So I thought I'd give you examples. If you were a prosecutor working in Los Angeles, the total number of filings per prosecutor is 190. The Cook County, which is the busiest criminal court in the country, that's in Chicago, 406 cases per prosecutor. New York, in Manhattan, it's 230 per prosecutor, and that's felonies and misdemeanors coupled together. Brooklyn, 269. So I put it up there so you could sort of get a sense of what prosecutors across the country are looking at. And then when you compare that number to what we were looking at for us, 566.5. So sometimes it leaves you in a position where you feel like that old Lucille Ball chocolate conveyor belt image that you see. And sometimes you feel like the cases just keep coming in and you're trying to keep up, and then you start shoving the chocolate in your mouth and you're just trying to just make sure you're doing right. And the image is somewhat amusing, but when you're talking about the requirements and the ethical obligations of a prosecutor and you're trying to do right by each case that comes through the door, it can be incredibly stressful. We have, in fact, captured a photograph of prosecutors that start working in the office and realize the actual volume that they have to deal with. Now, when I talk about volume, I thought I'd give an example. Each case, we have to comply with the constitutional, the statutory, and the ethical obligations that go along with each case. That requires us to provide discovery. So for every piece of paper that comes in from law enforcement, that has to be given to the defendant. In 2005, when you had an OUI, I think you would see maybe a cruiser camera, maybe 3 pages, and an intoxilizer. In 2018, there's usually 3 videos. There might be a lapel camera, there might be an intoxilizer video, then there's the cruiser camera video. You then have the reports. Oftentimes the discovery request for the chemical analysis of the intoxilizer machine. They want expert reports. And the volume of what used to be, I think, a pretty simple case has become pretty complex. And that's not just on OUIs. You can see it sort of gets extended to all the different types of cases. And I thought this was kind of a fun example. When I first came in as DA, in this discovery letter was in the file. This is a Class E theft of a bicycle where the person had possession of the bicycle when they were located. This is the discovery letter that we received from a defense attorney. So this is the lowest, probably the least significant case we were going to deal with this year. This is the discovery letter they're asking for. That's page 2. That's page 3. That's page 4. That's page 5.
Sweet bite.
You know what? The kicker, it wasn't even that good a bite. This is page 6. So you can, this is a case where we would not spend an extraordinary amount of time when you're dealing with where are you going to spend your resources and your time. And you can see what we're being tested on just the lowest level case. When you start getting into the attempted murders, when you get into the significant OUIs with bodily injuries, the discovery exchange explodes. And there's a ton of work that goes along with that. Put that in contrast to our colleagues in Los Angeles who have 270 cases. Well, you get it, and you've got to spend your time there. When you have 560 cases, you've got to keep moving because the next case is coming through the door. So make your decisions, find what you have, send out your emails, move on to the next one, wait until you get a response, and that's how we function because we are overloaded. Along with these cases, we have statutory obligations, ethical obligations, because it's just the right thing to do, but you have to get in touch with your victims. And then you have to keep them updated with what's happening with the case as it proceeds through the criminal process. And not every case has a victim, but there are a lot of victims. And in the era of 2018, it's you call, you get a voicemail, you leave a voicemail, they call back and leave you a voicemail. You're trying to get a hold of that person, and each one of the attorneys has 560 cases, and they have a trial assistant working with them, but you're constantly trying to get information back and forth And it's taxing and it's overwhelming. Each case needs to be prepared for trial, and that means securing your witnesses, ensuring that you have all of the evidence that you need for trial to be able to prove it, even though we know the majority of cases don't go to trial. And I thought we'd take a moment to look at that. We know in Androscoggin County, based on the court's reports, that there are 5,382 cases. If you just divide that by 12, that's 448 cases, 0.5 per month. On your best month, you'll get 14 to 21 days. My cruise reminds me this is exaggerated. It's usually closer to 9 to 14 days a month. So just do the math. If we know we're only going to get, best case scenario, 21 days, and there's 448 cases, what has to happen? Because in the end, if you don't resolve those cases, there's 448 coming the next month, and they need to go to trial. And if you don't resolve there, there's 448 coming after that, and they need to go to trial. And if you get a backlog, you'll start getting into years of backlog. And the court will tell you, look, everybody has a constitutional right to a trial, and they honor that. And I know they sincerely believe it, but they also tell you which cases on the docket have been around the longest. And they also tell you that's the one they want to get resolved. And that's the one where motions to continue don't get granted and you're forced into a trial when you may have difficulty securing your witnesses because they went out of state. And then there's nothing you can do about that.
So who sets the 14 to 21 days?
That's the court.
Okay.
That's what the court has available.
Availability.
Right.
Okay.
And, you know, that's generous for the number of days we're going to get. But even if you said 14 to 21 days, you're talking, if you can get one judge, you're in a good place. If you get two judges, it's like a gold mine. But running two trials over in the Superior Court hits their resources hard with judicial marshals and clerks and trying to get everything moving at the same time. So even if you doubled it up, though, and you said, okay, well, we'll have 42 cases because we did 2 a day for 21 days, you still got 400 to go. And that's our business. That's our reality. Other things we do, we provide trainings at the local law enforcement agencies, especially when there are law changes or legal updates, or if we've learned things, we go in and we try to do trainings during the shift changes. Sometimes we can coordinate specific changes, but it requires them to pay for the overtime, and that's difficult for their budgets. But we do go in and do trainings. We always have an assistant district attorney on call when our offices are closed. There is somebody designated each week who takes all the calls once the office is closed down, so that an officer always has access to a prosecutor to confer with about issues that are arising while they're conducting an investigation. And then here in Lewiston, our prosecutors who work directly with Lewiston PD indicate they should call them directly. And they often get the phone calls over the weekend when there's a significant event or something's happening, and they'll come in and do a scene view with them. They'll often be reviewing search warrants and documentation over the weekend, talking directly with Lewiston PD. We have an automated system. One of the things I learned when I first became DA, I went around speaking to all the different law enforcement agencies, and one of the frustrations that I think officers had was, we don't know what's happening with our cases. And so we went out, learned that our case management system can in fact provide automated emails or notifications. So we built a system, which, by the way, it was done sort of like bootstrapped and duct taped. It was me learning how to do it and then calling the software company, and we finally pieced it together so that any time a case is closed in our office, an email is immediately sent to the investigating officer letting them know what happened with the case. Because I think they have the right to know. If you've spent time investigating and putting your energy into it, you should know what happened to it when it came to the DA's office. And that's important, and it is consistent with our goal of ensuring we have communication and that we're working closely with our law enforcement agencies. Getting to questions that are often posed to me, and I thought I would sort of try to answer them in advance. Case delays. Why does it take so long for a case to get to trial? When a case gets into the criminal justice system, if a defendant indicates that he has mental health issues, if there are competency issues, meaning the defendant can't interact with the attorney in a meaningful way so they can help with their defense, then you have to get an evaluation done. And that means going to Riverview in Augusta. There's only one facility, and a lot of times that can take months for a person to get over, get evaluated, get the report generated, sent back to the court, and then distributed to the attorneys if it's going to raise any of the issues. If it does in fact trigger one of the defenses, then we either have to get an expert or they have to get an expert, and that takes time. So the minute you get into mental health issues that play into defenses or the ability to actually participate in the trial, it's going to slow things down. By the way, our work, I often joke with people that if you eliminated mental health issues and substance abuse issues, we would be the best solitaire players, in the state. Because the fact is, the things that drive the criminal behavior linked directly to mental health, it's incredibly frustrating because we don't have resources. The DA's office can't say we're going to pay for a counselor for you to go get treatment and then come back and we'll see whether or not, what the appropriate disposition is. We often have to say, okay, we're putting you on probation, and then probation doesn't have the resources to pay for treatment. The person has to go out and get on waiting lists with maybe Tri-County that has the sliding scale, or hopefully has some level of insurance that would pay for treatment, but most people don't. Or if they do, it doesn't cover the treatment that's required. A person has multiple cases in one jurisdiction or multiple jurisdictions. This is incredibly fun. When somebody commits a burglary in Androscoggin and then shoots up, does one in Franklin, and then goes over and gets to Kennebec, you have two separate counties, so two different court systems, and then you have an entirely different district attorney's district. So we work well together, we do communicate with our colleagues, but it immediately slows things down. If a person applies for our diversionary courts, you have the adult treatment drug court, you have the co-occurring court, which is when you have a substance abuse and a mental health issue, or when someone applies for Veterans Court, it can often take months to get the application in, have it reviewed by that court's team, get approval, and then coordinate things to have the individual actually go into the court, and that can slow down the process pretty dramatically. If a person fires their attorney, it's almost like you've got to start back at square one. So you can work on a case, you can get everything worked up, ready for trial, they come in, they say they can't work with the attorney agrees, they usually go into chambers and the judge makes an independent determination without the state being a part of it. And then if the attorney is allowed to withdraw, then you don't have your trial that month. You actually have to wait for another attorney to get the discovery, get back up to speed, and get ready for the next trial list. So it's sort of a built-in continuance. And then finally, we spend a lot of time, our Maine State Crime Lab is taxed because we only have one lab that does all of the testing for all of the drugs that are submitted in the drug cases to determine that it is in fact the drug that we're alleging it is. And then when we're looking for DNA results, the lab, when we're working with them, they do a priority scale. So if it's a crime against the person, you're going to get results pretty quickly, especially if it's a dangerous crime against the person. But then you start getting into property crimes, it can take a year, it can take 18 months to get the results back from the test that was done. I have folks that often ask me about, I think one of the questions that was posed before, hey, are people being arrested and then immediately being released from the jail? Or sort of are people being held in the jail too long? It's funny, sometimes I will go to a community meeting, and this happened on one day of the week here where folks were pretty frustrated with criminal trespassers that were sort of loitering and staying in locations where the property owners did not want them, and they were frustrated they were getting arrested, but then they would be there the next day. And then I went to a county meeting the next night, and the county commissioners were bemoaning the cost of the jail and the incarceration of people. And I was thinking, man, we're not making anybody happy here. We're trying to find a happy medium. And in 2015, there was a study done by the court system for pretrial detention. And so they put a report. This report is actually on the Maine State Court webpage. And on this report, you can see we sort of strike in the middle. When they did a one-day sort of snapshot, we had 339 inmates based on 480 bookings. In Two Bridges, which is out on the coast, they had 165 with 237, and the Aroostook County, 148 and 262. So they were below us, Then if you look at Kennebec, they were slightly higher than us, 367 with 670 bookings. And then you get to Penobscot, 548 inmates with 918 bookings. So they took one day out of the month and just looked at what was happening with the jail population for pre-conviction jail population. And that's what it looked like. We're in the middle. I mean, you would sort of expect us to be if you're trying to balance the cost and the resources necessary to hold somebody and the actual public safety concerns. And that's what we try to focus on is there a public safety risk? And if there is, then they need to be detained. If not, they still go through the criminal justice process and they still have consequences for their behavior, which may include a jail sentence, but they don't sit in jail waiting for it. If there is a public safety concern, then we don't have any qualms saying they should wait until we can get to this case and keep the public safe. That's sort of the test that we use. This was interesting. So in that same study, they looked at the average length of stay for new criminal offenses, and I think this reflects what you would want to see your DA's office doing. On the significant charges, and I think we are the first line in the column there, on the significant charges, Class A, Class B, Class C, yeah, they're getting lengthier stays, and if you look at the less significant, the Class Ds and the Class E's, they're much smaller. That's what I think the jails are supposed to be doing. Your lower level cases have lower level of jail periods, and the upper cases, or the more significant cases, have the more significant sentences.
Can you give us an idea of what falls into each of those classes?
Sure. A Class A charge would be an aggravated assault, an elevated aggravated assault, so pretty significant injury was sustained and somebody used a weapon of some sort. A Class B would be akin to a residential burglary. And Class C can be anything on the spectrum from your third offense OUI to operating after revocation with one prior OAR to a burglary of a garage to an aggravated assault that doesn't have the serious bodily injury or that didn't have a weapon of some sort used. Often an aggravated assault on a Class C would be because you have 2 priors or 1 prior domestic. That would make it a Class C felony. And then Class Ds and Es are what you think they are. Class E would be disorderly conduct, operating without a license. And Class D can actually be important cases like an OUI. A first offense OUI is a Class D, or a first offense domestic violence assault with no aggravating factors would be a Class D.
So violent crimes are Class A and maybe Class B?
Violent crimes are in all categories.
Okay.
Because that DV assault, that domestic violence assault,
Right.
that's a misdemeanor.
Right,
It's a Class
okay,
D, and it,
okay.
it involves violence. But the Class A is
It
what...
should be higher.
Well, it gets there pretty quick. If you have 1 prior, it becomes a felony, becomes a Class C. The A's and B's, though, a Class A is what is where your mind is going. It is the most significant felony short of a homicide that you can have. Compulsion GSAs. If you had does everybody know gross sexual assault is a GSA? Arson. When you're burning down a residence, that falls into the Class A. These significant cases fall into that category. And remember, these are the sentences for the count, like where someone is in the county jail. They may leave the county jail and go off to the Department of Corrections. They were just looking at how long are they staying in the county system. Because at the time that this study was being done, who's paying for the jails was the biggest question mark. And folks were looking to see who's being detained pre-trial, what's happening while they're there, and what kind of cases are they being held on.
Can I ask a follow-up now that we're on the jail, and maybe this is more appropriate for the sheriff?
Yeah,
but,
yeah.
How many inmates are down in Cumberland?
You mean right now?
Yeah, well, I meant for that day and time.
In that day and time, I don't know the answer to that. There is and I'm not sure if it's Cumberland or Two Bridges that they're housing them at,
Okay.
but there is an overflow. And at our last department head meeting, I think it was 28 or 30 inmates that were being transported to
How
or
does
housed
that
at other
determine
facilities.
who's not in this jail where they can?
Well, it's a head count. I think they just meet a tipping point.
As someone comes in, there's no room.
Yeah, and they say, and it may be, and it would be better answered by the jail personnel, but it may be that there is somebody that is there for a longer duration, so they know they're not going to have court anytime. Maybe they received a 6-month sentence,
Okay.
and they're going to be in the county jail because anything under 9 months and a day is going to be in the county. So they'll send them off knowing they're not going to have to transport them back and forth and
Okay.
keep the new case here because that person's going to end up in
Need to
court
go
pretty
to court.
quickly.
Okay.
But that's me guessing. It makes logical sense.
I'll ask the sheriff. Thank you.
Yeah, and the other thing to know about the sheriff is committed to public safety. He is constantly feeling the pressure of the budget in dealing with head counts and dealing with the daily cost of an inmate. But anytime you talk to him, he will say to you, look, what else can we do? It's public safety. If they're supposed to be incarcerated, then we have to hold them to make sure people are safe. And so that balance is always in his mind also, but that's the strength, that's the tension. We do have a lot of conversations about human trafficking. In our area, what we have done is we have formed a collaboration, and we are working with the folks that you would expect us to be working with: sappers, safe voices, local businesses, local law enforcement, federal law enforcement, survivor leaders, Department of Corrections, Pine Tree Legal, DHHS, and other community members. And this group meets on a regular basis, and they talk about the issues and come up with plans on how to provide resources, how to divert people away from the trafficking in the community. And we also work very closely with Lewiston PD on any coordinated human trafficking operation. And if they're working on an operation that's targeting the sex workers, then they're arrested and provided with bail at the department so they don't go to the jail, but they're given conditions not to return to the streets where the activity was occurring. And that was important to us because we know it's important to the community to be able to have a cessation of the behavior, that they don't want folks continuing to return to the same location, behaving in the same, or engaging in the same conduct that was causing the issue. If they return to the streets, then it's a violation of conditions of release, and they are arrested. And this has happened, where people then remain in custody. And it's not our favorite result, but it is a mechanism we use to try to ensure that the community has a response or sees a response to the trafficking that's happening. Does that make sense?
Yeah, got a question on that.
Sure.
It seems to me the human trafficking definition has been, thrust upon us.
It's evolved.
Yeah. So how do you define that, and how is that different than the way we've labeled it before?
Sure. It is it's statutory. The legislature revisited the entire sort of statutory structure for what we're now calling human trafficking. It was behavior that used to be discussed in terms of prostitution. It was, they've looked at it and identified it as a unique circumstance where the person engaging in the behavior is behaving in criminal behavior because it's not allowed, but they're also a victim. And they're looking at it from that perspective, and the modifications make it, we sort of reflect what the statutes were modified to reflect. That first offense if you were charged, there's no jail involved. It has to be a fine if you're a sex worker. So we're looking at that and saying, okay, it's very clear they don't want people incarcerated for this type of behavior, especially not on the first time. If there's a prior, then clearly they're continuing to engage in behavior, and that has to be addressed with a more significant consequence. But the way we coordinate this is the person gets arrested, they go and they have conditions not to return to the streets, but at the same time, these groups, these wonderful groups that are trying to provide support and programs and assistance are there that same evening and offering different services and alternatives right there and then. It would seem to me Lewiston would be proud of the way that this is being handled because it's very humane, but it is also ensuring that there's a consequence if they're not complying with the rules of not going back and continuing to engage in the behavior. Our goal, when it finally makes its way through the system, is to identify a mechanism. We have a sentencing mechanism that's called a deferred disposition, where a person can plead to the charge. We then continue it for sentencing, and we tailor what their conditions should be. If folks that are engaging in human trafficking and who are acting in the capacity of a sex worker typically have a history of trauma, and it's sexual trauma, it's addiction, it's usually financial issues. They're all there, And we're trying to get a handle on those because we believe, and I think that it's a fair conclusion to reach, that if a person is able to address those issues, they can start to stand up and engage in more sort of healthy behaviors and then move on to be a part of the community that everybody's proud of. And that's our goal. The other alternative or the other operations that we get involved in is when it's the John and they're doing a sting on the Johns. In those cases, we're publicly identifying who was arrested, and we're recommending jail sentences. The theory being, it's not lost on you, that if you can deter the people who are demanding the services from coming to Lewiston, then the folks aren't going to be interested in standing on the streets anymore. And hopefully, sitting in the background, they've been able to engage in the services, and they got better alternatives anyways. That's what it looks like. It's a good way to handle it, and we should be proud of the way we're handling it. Firearms cases are obviously a greater concern more recently. We have been working closely. We have prosecutors who are assigned to Lewiston PD. When a significant event like this occurs that involves a firearm, they reach out to the prosecutor. The prosecutors will often go to the scene. They'll help coordinate search warrants, any kind of documentation. They'll talk to the officers about the information we're going to need to be able to support the charges. We also are working with our counterparts in the U.S. Attorney's Office on possible federal charges. We work with the ATF. There's a program called Project Safe Neighborhood that has been funded again, that we're working with the U.S. Attorney's Office to bring them back into the Lewiston area. The number one difficulty that we face with these cases, and this is an interesting way to sort of analyze the difference between probable cause and beyond a reasonable doubt, but if you have a firearm case or a shooting case between two gang members, and you talk to one of the officer talks to the person, interviews the victim, they identify who actually shot them, they can rely on what the person told them to formulate their probable cause and make an arrest. It's perfectly appropriate. The issue for us is the standard when you bring it into our office and we go to trial is beyond a reasonable doubt. It's the highest standard you can get in a court of law. And it should be, because the consequences are Class B assault charge. So you're facing up to 10 years in prison. We have to be able to prove the case beyond a reasonable doubt. And if the victim says to us, I'm not testifying, or more commonly, I don't remember who shot me, then we're in a position where we can't prove the case where an arrest, a legitimate, bona fide arrest occurred, but we're heading into the courtroom and we don't have, and we know we don't have sufficient evidence to prove it beyond a reasonable doubt. And that's a frustrating position to be in. On the other hand, when we do have our evidence, we are trying these cases. In fact, we recently had a series of articles talking about the jury selection process, where it was in fact one of the shooting cases, and they were railing against the process, but what everybody wasn't noticing was that we were prosecuting someone for firing a gun downtown Lewiston, at another individual, and they went to prison. So we take the cases seriously. We're working with every partner we can find, and then we do everything we can at the beginning to help build as strong a case as possible, and a lot of it, though, is contingent upon what we have for evidence when it's time to go to trial. And that can be very different than what the officer had at the time of the arrest, and that can be frustrating when you're reading that in the paper, because what is a common practice is the paper picks up the probable cause affidavit and cites all the facts from it, but doesn't mention, and in court, the witnesses didn't show up. And so you're left with the impression of everything they had on day one, but don't have an understanding of what we were dealing with on the day of trial. And so we have to make decisions accordingly, sitting in the background of, you've got 400 other cases, you've got to deal with that during that period. And by the way, of the 400 cases, about half of them would resolve at arraignment, probably another 25% would resolve at what we call the dispositional conference, and then you would probably have 100 or so left when it gets to trial. So it's not fair to leave you with the impression there's 400 for those 21 days, but that month has 400, and 21 days is all we have. So that was sort of helpful to see it. But you got about 100 cases on those 21 days that you got to look at.
Can you just describe a little bit about Project Safe Neighborhood is?
Yeah, Project Safe Neighborhood is a federally funded project where the U.S. Attorney's Office has been coordinating with all of the local law enforcement agencies. And probably the most significant aspect of it is one that's called Hotspot, where a lot of agencies converge into specific neighborhoods where there are some concerns. And every individual who has random search provisions, whether they're out on bail or because they're on probation, they go in and do those random searches. And they just do a search around residences, to determine if there's needles or if there's any hidden guns or things like that. It's been pretty effective in the past.
Thank you.
Yep. Thank you. I have, I know I talk too much, and I know I put a lot of information out there. I tried to address things that I thought, just standing objectively, I'm not sure everybody knows the nature of what we're doing and what's happening in the background. On the other hand, if you have specific questions, I'm happy to answer those. And I want to make it clear, this isn't the one bite at the apple, the DA walked in, talked to you for 20 minutes and then left. If there are ongoing discussions, I'm happy to engage in that. I think it's important for folks to know the work that we do and why we do what we do. So.
Any other questions from Ken?
So a couple. One, when you talk about your caseload, wondering if you have a sense of the breakout between adults versus juveniles?
Mm-hmm. The adult caseload, that 8,300, I can't remember the exact number, those are all adults. A juvenile caseload probably sits around 250, 300 cases a year.
Okay.
It fluctuates a little bit, but it's much, much lower. Remember, the juvenile process has a completely different philosophy behind a statutory structure. It's a much more rehabilitative, a much more trying to prepare the child or the juvenile to become a good citizen when they become a grown-up. And so there's a lot of diversion that occurs before you even get to court, where the juvenile corrections officer actually puts them on what's called an informal adjustment. So a case may not even see the courtroom because they're dealing with it outside of court.
And a lot of those decisions aren't made through your office. They're made before they even get to your office.
That is correct. Although if you're doing that mechanism I'm talking about, the informal adjustment, they submit a notice to my office indicating that's what's happening. We review it, and if we object to it, then we can file a notice to them that we want it sent in anyways.
Okay. And then secondly, one of the bigger complaints I hear is about overcrowding at the county jail. And so I'm just wondering, are we going to see a remedy to that at any point in the near future?
I understand the concern.
Because, again, when we talk about the sheriff and his public safety concerns, I mean, there's public safety concerns for people being out on the street. I think, he also has concerns about his people in an overcrowded jail.
I agree wholeheartedly.
Yeah.
And, look, cases in my, where we look for is there a public safety issue? Sometimes you also see it on probation violations where maybe it's not as great a public safety issue, but the person was already out on probation and had a court order as to what they should do and what they shouldn't do, and they were violating that. So then it's pretty clear if you've indicated they violated that putting them back out on the streets to violate again isn't going to do any good. And so I have talked to my crew and I've talked to the sheriff and I've said, look, if somebody's coming in on disorderly conduct and they're sobered up, then, obviously we don't want them detained. And everybody in the office looks at me like I have, 3 heads because they're like, yeah, we know that. That's not who's detained. And they're right. If you go and look at the list of who is actually incarcerated, especially those for the longest duration, it's significant cases. And I keep finding myself in this position where I do not want overcrowded jails. I'm not happy about pre-trial incarceration because the person hasn't been proven to have committed the crime, except if I'm concerned about the welfare of the people, the safety of the communities. And when I look at the list and I go through, I don't see the shoplifter that's being held on $100. We don't do that. It's domestic violence cases. It's multiple OUI cases. It's significant cases. So I hear you.
And
I understand
Eric
it.
has also, agreed with that he's looked at the list and he's like, I don't know who I would let.
Because look, you need to know, Eric Sampson, the sheriff, works very hard and believes in public safety. But he ribs me a lot about that head count. And he attributes it all to me, like there isn't a judge in the process. And
So I guess that's what I'm trying to get at is, you know, when we talk about the holdups, I mean, I feel like it's easy to sort of lay the blame on your office, but there are other people like that are contributing to that. And so I think it's important for people to hear from you and to sort of understand like what those other holdups are, I guess.
Well, and look, here's the thing. I'm the district attorney, so I'm responsible for our decisions, and I'm okay with that. And if folks have questions about it, I'm happy to talk about it. But the end result is everything that goes through the courtroom has been approved by a judge. That is not the DA's office just waking up one day and deciding everything that's going to happen to everybody. There's actually a neutral party that's responsible for ensuring that right decisions are being made, and that's happening. And then when you talk about overcrowded jails, the exercise that Eric's done, that I've done, that I think anybody can do, is look at that list and tell me who we should be releasing. You know, sometimes it's tragic. Sometimes it's someone with significant mental health issues, and it doesn't help for them to be incarcerated. But we don't have a facility to send them to. So it's keep them there and keep the public safe, or it's release them, worry, and then history has shown, end up putting them right back in and arguing the next case with a new victim. And we don't want to do that either. The answer, I mean, ultimately, if you said to me, Andy, here's your magic wand, fix this, I would say to you, pay for mental health treatment.
Yeah.
Create a venue or an avenue where we can divert people away and they actually can engage in the services. And I'm not Pollyannic about it. I know there are some people who are, in fact, ill-intentioned and bad people, and they need to be held accountable, and we do that also. We work very hard to do that. But a significant number of people that end up going through the criminal justice process is because they have mental health issues or they have substance abuse problems, and they can't get a handle on it, or they keep bumping against the law while they're doing it, and then we keep incarcerating them, and they keep spiraling down, and then we turn them back out, and then they get arrested again, we prosecute again, and we just keep going through this cycle. That happens.
Thank you. And then lastly, and we've talked about this briefly, is how we get the word out about what is happening in terms of prosecutions and what your office is doing. And I think that the Sun Journal or the media covers it when it's like a big trial, when it's like a big case, when it makes headlines. And so we do an administrator's report, or Ed does an administrator's report almost monthly?
Pretty much monthly.
That I'm wondering if maybe we could include the Androscoggin County District Attorney statistics in. I think that might be a good way of sort of getting numbers out there in the same way we do with the police department.
Yeah, and we've had conversations about that, and those, I think we can compile numbers and data that's helpful. Just like we're getting information to the officers, we can to the public. There are some governing things that I don't think we're going to bump into, but because of the CHRI, which is the Criminal History Records and Information Act, we are limited on what information we can share on a specific individual, but we're not limited in speaking in generalities about percentages or numbers, and we can definitely share those kind of things.
Okay.
What doesn't come across is if you have a domestic violence trial ready to go, and the victim walks in and says, I'm recanting. I'm not going on the stand to testify about what I talked about when the arrest occurred. That doesn't show in a number, so it'll look like a case that was resolved and not tried, even though the state has done everything it can. On the other hand, folks should see it. They should see what's happening with cases in their community, and I'm happy to share that.
Okay. Thank you.
Thank you. So I had the benefit of shadowing your 3 ADAs for half a day, so thank you to your office for that. One thing that struck me, and I don't remember the numbers, so I'm going to ask you, was the ADA breakdown throughout District 3 and how many folks are assigned to the Lewiston office as prosecutors?
We have 14 ADAs and 1 AAG. The AAG is an Assistant Attorney General, so they work for the AG's office, but they're embedded in our office. So the way it works, there's 9, that AAG right now, half of that position is in Androscoggin, and then there are 9 ADAs. In Oxford County, we have 3 ADAs, and then in Franklin County, we have 2 ADAs.
And that case breakdown that you talked about earlier, is that across all of District 3 or Androscoggin County?
The percentages that I showed you?
The 566 cases?
Yeah, that's roughly on average. It actually goes up when you include the other counties and the other 5 attorneys because the numbers are higher.
Okay.
But it's in the ballpark. I think it comes in around 580.
Okay. And then my last question, and it's sort of open-ended, I can see how there is frustration and tension between enforcement agencies and the district attorney. It is easy to blame you, unfortunately.
Sure.
I think you're a great scapegoat. I don't know.
That's not new, by the way. That's not like, Andy became DA and suddenly people discovered you can blame the DA. That tension has always existed.
Right. And so, you mentioned doing trainings, but are there other more like different communications that happen between the enforcement agencies and the prosecutors in order to build more of a relationship going forward, so that it's an understanding that, this came from the legislature or this came from here, rather than me just making a decision like this?
Yeah, one interesting product of the unified criminal docket, where before you would have a trial day in the district court and you would bring in all of your officers. And so there was usually a day or two a month where all the police officers converged on the court with the prosecutors, and while you were waiting, you had a chance to communicate and talk. Then when the unified criminal court came along, there are no trials in the district court. And in fact, by the time you get to the superior court, you've identified the ones that are going to go to trial, and you have a docket call the day before, and then you try to narrowly tailor it down to what cases are actually going to get picked. And those are the officers that get subpoenaed. So you really don't have that day in time where everybody's in the same room or in the same building working together. And it's created a distancing between the prosecutor and the officer. Now, what you should know is that we do communicate as much as we can with law enforcement. When we receive a case and we're trying to make a decision on it, if we think there needs to be follow-up, we send emails and we talk to them about that. When I meet new officers, they're usually brought in and introduced to me. I explain to them we have an open door policy, and if you have a case that's important to you or that you have questions about, you should come in and speak with the prosecutor that's handling that. When a case is getting ready for trial, just as I have an automated email that goes out telling you what happened with the case, it's an email that goes to the law enforcement officer and says, this is the prosecutor handling this case. This is the trial assistant that's working with them. If you have any concerns, communicate that. And by the way, we're set for trial in this month. So we need to know if you're going to be available. So trying to make sure they know who to contact and who's available to discuss it with them. And that can be frustrating. But in the end, what is important is to remember the DA's office is not a rubber stamp of decisions that are made by law enforcement officers. We're an independent agency, and we want it to be that way because we have to make our decisions based on what we can prove in court under that beyond a reasonable doubt standard with the resources that we have. And that's not going to be the same decision that's made by a law enforcement officer on the street dealing with somebody who's raising heck, at the moment. And I understand that, and that can lead to frustration. But I think you would find if you spoke to officers, it's not an alienation. Everybody who knows our office knows you can come in and talk to us, and we want to talk to you about your cases. So that is important, but the trainings are important too.
That's great to hear. And then the last thing is just a quick comment that you talked a little bit about certain pressures, but the pressures I saw that day from defense attorneys and judges, and it was so hectic, having never been to court myself. So I just commend you all for the level-headedness that you're bringing to this position and being so open to spend even more time explaining this to lay people like us. I really appreciate it.
Well, thanks for mentioning it. I got to tell you, I'm very proud of my staff, and I think if folks had a chance to see how hard they work, the flurry of emails that get exchanged over the weekend while they're preparing for trial, or when they're getting phone calls from officers and they're just brainstorming what we should be doing next, their commitment and their passion for ensuring that justice occurs and that we keep our communities safe. It's awe-inspiring. It makes me very proud, and I know sometimes that message doesn't make its way down the wire and people don't have a chance to see it, and that can be frustrating when people don't have a chance to know how hard people work or in our office are working.
Anyone else on the council? Council Marco?
As I've heard your workload is a tall order. Where are the funding sources to cover the expenses of your department?
We are a county office. In 1976, prior to that, a county attorney was just like the probate judge, just like the registry of deeds. It was a county function. But what kept happening is counties couldn't afford full-time attorneys, so it would be a part-time position, just like the probate judge is. And a person would graduate from law school, become the county attorney on a part-time basis, get the experience of a litigator, and then leave to go make money as a defense attorney to make full-time. And then a new prosecutor would come in. And what they realized was you had incredibly experienced defense attorneys and incredibly inexperienced prosecutors. And in 1976, the state adopted the criminal code and then adopted a system where they went to the counties and said, we will pay for the prosecutors, but you have to continue to provide the offices, the resources, and the support staff. And so you have this kind of neat amalgamation of two state employees and county employees working together for common public benefit. But our budget, it's funny. Defense attorneys will often make the argument, the state with its vast resources sits here and brings you this evidence where my poor innocent guy, doesn't have a penny in his pocket, and this is what they've given you. My budget line for experts is $1,000. That's it. That's what I get for a year. And if there's one vehicular homicide, it's gone. We're limited to the budget that the county is able to provide to us, and they're obviously limited by the amount of money they have coming in from taxpayers. So the only other resource I have is I have an extradition fund that is funded by people who don't show up to court, so their bail is defaulted. And we use those funds to bring people in from all over the country who flee the jurisdiction and then get picked up or arrested. But I can sometimes use those for trial expenses too, so I use that fund when I can.
So specifically, what does the county cover, and what could it cover to enhance your efforts?
The county provides the support staff. And so by way of example, I went back to them this budget cycle and asked them for an additional trial assistant, because just as I'm showing you the statistics for the prosecutors, we all know behind that prosecutor is a trial assistant who's even more swamped, trying to keep things functioning and moving along. So I go to them for all of the support staff, and this year they've afforded us one more position. So if you looked at those numbers, you would see we're still way understaffed, but knowing the limitations of the budget, we asked for one more and we received it. And so they've provided that. The county provides all of the resources you can think of. They pay my rent. They pay for the desks, they pay for the paper, they pay for the printers and the computers. I mean, everything that goes with being a medium-sized law firm, which is essentially what we are, they fund.
So to reduce the caseload, you need more ADAs. And who would pay for the ADAs? The state?
That's the state. And we have asked for 17 new positions in the transition budget, I think they're calling that, from one governor to the next one statewide, with an expectation that we would get 3 of them.
In this district?
In our District 3, yeah.
Okay.
So you mentioned juvenile cases and whatever, and I wanted to explore that a little bit with you. And I appreciate you coming in and talking to us, because it's not a very understood kind of complex
I appreciate that.
So, and obviously we appreciate what you're doing too. So, with limited resources, we know as a city that we run into the same problems here and there. So, but youth court and restorative justice, do you get involved with those programs? And because I'm interested in those, that kind of focus of how do you have an alternative to going through a process, especially with youth.
Right. The restorative justice programs, actually, we do have a team that comes in and works with us. The way it generally works is the JCCO identifies cases that the restorative justice program would make sense for. They then refer the matter to the restorative justice program. They determine whether or not they can work with it. We get informed that a case has been diverted that way, and if we agree with it, we send it over, and then they go through the process. Restorative justice is interesting. It is a much more resource-demanding process. Although, when you talk to victims in those cases that have gone through that process, where they have had a voice at the table and spoken directly with the defendant or the perpetrator of the crime, and that person has communicated what they were thinking and what was happening, I think most people who go through the process find it a much more rewarding process than a phone call from the DA's office saying we're recommending a $100 fine, and them saying, okay, well, can I come to court and be heard? And that's sort of the extent of it. So it's really a dramatic improvement in the way a case can be handled, but it is so resource demanding that it's not an option in the adult world. And the reason it's an option in the juvenile world is because it's a federally funded program from the juvenile justice grants that go in through the Department of Corrections, and you have organizations that have written grants to be paid for, where they in fact create the restorative justice program. So when we have an opportunity and we have appropriate cases, we absolutely participate in it, and because I do think it's a better outcome. The juvenile court, Judge Dow, will shake his head when he hears me commenting on it, because he repeatedly tells me when he needs me to be there, and I repeatedly get conflicted out of it. But we do believe in the program. That's when high schools are actually participating in what would be the equivalent of a restorative justice process. And I know he works closely with it, and then we intend to have a prosecutor participating in the programs when they have sessions.
My other question, if I can, obviously the opioid epidemic, addiction epidemic. Just some of your insights from your office, more pointed toward, where do we go from here? How do we, similar to the mental health issue that you experience with
Substance abuse and mental health.
And
Yep.
substance abuse are sometimes co-occurring.
Absolutely.
So, but obviously this is something that we're struggling with as a city, struggling with it as a state, as a nation, whatever. So your insights?
Well, it goes back to that treatment. When I was talking about treatment, I wasn't just talking about mental health. It's about substance abuse also. Because what happens is, let me make sure that everybody's on the same page. The felony drug cases are handled by the Attorney General's office for the most part in our district. And we'll help when we can, or we'll run interference, especially because they're down a lot of AAGs right now. But we will coordinate and try to help. But here's the thing. If somebody has a trunk load of drugs and they just drive into town to sell it, nobody has any questions in their head what should happen with that case. That person should go to the Department of Corrections. They should be going to prison because they're here to peddle poison and make money off of it. So that's fine. And the person who just has the drugs for their own personal use, so it's a possession case, it's on the lower level, that individual needs treatment. They need to grapple with their substance abuse issue. And I don't think anybody spends much time worrying about that either. That's what should happen. Now, whether they can get access to the substance abuse treatment, that's the frustration in those cases. Where we spend the majority of our time in angst is the person who sells the drugs to make enough money to buy the drugs for themselves, or to get, the dealer comes to them and says, here's the amount we want distributed, you get a quarter of it for your own personal use, the rest you have to sell and bring us the money back. So that person is a dealer, but they're also an addict. And you've got to find where they are on the spectrum and then determine what course to take. If they're going to continue to be a dealer, then they're a risk to the community, and they're going to end up killing somebody. So they have to be taken out of the community. If they're an addict, then they're usually, they're living a pretty pathetic existence, and you're trying to get them to a point where they have a clear head. And when they're there, majority of the time, they're not engaging in criminal behavior. And so, boy, we spend a lot of time. In the end, if you said to me, Andy, what's the cure for the opioid epidemic? Because I have the answer that nobody else has. It's about treatment and making it available. And right now, it isn't. It's too easy to get a quick fix and go track down drugs than it is to actually engage in treatment and get help and support.
Thank you.
Any questions from council? Chief, anything to add? Any comments?
The Project Safe Neighborhood, I know we've heard that hotspot word for some of you who've been here for a while on the City Council. We did apply again for that grant. We were turned down. What usually happens is the federal government doesn't give it to the same community over and over. So back in 2014, when we got it, we got about $250,000 that we could spend on overtime, which I would love to have that again, but unfortunately, we did not get that. And I would say that Andy's office is a bunch of dedicated prosecutors, hard workers. I mean, I just had a couple of the ADAs in my office the other day just communicating. They come into lineups, they do trainings. My officers do express frustrations. I think they express their frustrations to some of the members of the council during the last contract negotiations. And a lot of it comes to the demands that are put on them in terms of producing the reports and the technology and the time that takes to produce that. And Andy is correct. This isn't something new, because I know when I was a patrolman, I used to blame Janet Mills and Noam Croto for stuff that would happen, because they were the DA at the time. And what happens is these ADAs have a very good working relationship with my detectives. They're on the phone. You know, a lot of the higher end of the felony cases, they communicate directly. But we also have to look at the fact that if one of my officers who works, 11 at night to 7 in the morning makes an arrest, and then they're trying to get information from these folks who work during the day, it is sometimes difficult for the communication. So I've seen a progression in the ability of the DA's office to communicate. Sending the notifications to the offices is a big improvement in what used to happen. And of course, all the officers want everybody to go to jail and to get a big fine. And what comes with time on the department is they realize that doesn't happen with every case. But it's still frustrating for the officers, and they see the victims of the crimes day in and day out because they're here in our city. But I do see that the DA's office is striving to improve, which we all can do, and they're overwhelmed. And you look at the number of cases they actually present to court. They also review a bunch of our cases and make decisions on whether or not they're going to even prosecute. So that even increases the caseload for the ADAs. But also realize my officers are the ones that are preparing all those cases that they're reviewing, so they feel the frustrations and being sometimes overwhelmed with the amount of time that they spend on these cases. So we often communicate between my agency and the DA's office.
Just to follow up on one thing you just said, Chief. Last night, the Lewiston Youth Advisory Council, is that?
Yes.
Did their True Blue thing on the local police department. And one of the answers to one of the questions they asked related directly to technology and how sort of the increase in technology has actually led to an increase in the workload on the part of your officers, but it also sounds like on the part of your staff. And so I think it's easy for us to say, well, 10 or 20 years ago, we didn't have all these holdups, and I think it's important for us to recognize that technology has kind of led us to some of these holdups in some ways.
That's correct, and I think what is expected now, unfortunately, with television shows is if you go to trial, people expect to have DNA and fingerprints and photographs and a video of it all. And I tell a story of our case that she's a judge now, Deb Cashman, tried for me. It was a woman who was sexually assaulted by 2 men. And one of them was convicted and one of them wasn't. She told the exact same story, and the only difference was we got DNA from one suspect and not from the other. And they tried at the same time. She testified once, and I think the jury said, well, we've got DNA from that guy, so we'll feel okay saying he's guilty, but they didn't get DNA from him, so we didn't. And that was better than 10 years ago. So the technology has changed, and I think because there's an expectations of juries to say, well, you have a digital recorder, you should record this victim, or you should record that witness. And that gets frustrating for the officers because years ago, they would say, okay, I pulled this car over, they went through a red light. Well, produce the video that they went through the red light. And that, what used to take 3 minutes writing a paragraph out what they observed, they now have to drive back to the station, upload a video, download it, upload it again, and write a report. And I think that's where you see a lot of the frustrations of the officers of, isn't my word good enough? And that's where they kind of get frustrated. But that's the expectations of society now, and that's what we have to deal with.
What's on the council? Okay, so I'm going to open it up to the public. If anyone wants to speak or public comments, or actually Mr. Robinson's agreed to answer questions, which I'll bring him up here so he can face people and it's not the voice from the back of the room. And let's get us.
Hi, Andy. How are you?
Good, Pauline.
My name is Pauline Goodis. I live on Raymond Avenue in Lewiston. I do have a question. I'm a numbers person. And you're throwing out 5,300 cases in Androscoggin County a year?
I'd have to double check, but yeah, I think it's.
How many of those are traffic cases versus criminal? And you can eliminate, you don't need to count the OUIs. I
And
understand.
none of them are the traffic cases that would go through the Violations Bureau. It does include the civil violations like possession of alcohol by a minor, something that would go through the criminal court. So it's not speeding cases or DCVB cases as we look at them.
And the second thing is there's been a couple of meetings that I have attended with you and several other people, a couple of city councilors, and you have agreed in part to provide some sort of transparency as to the case volume, arrest, convictions, and it's been 3 months and we've yet to see anything. I mean, I'm not trying to put pressure on you, but...
But she's trying to put pressure on you.
I mean, 3 months is 3 months, and it's an expectation that I think one of the problems that's occurring is the absolute frustration that things in Lewiston appear in certain parts of the city not to be as safe as they were 10 years ago. And Brian is right, Chief O'Malley is right. People have expectations that an incident occurs and, God, within 36 hours you have the DNA results, the fingerprints, you've got everything done. That doesn't happen. I realize that having been in the field for 30 years. But I think what you need to do and understand is that people in this community are very frustrated by the quote-unquote lack of what is happening in the prosecution and convictions of people who are arrested by the police department. We have a very overworked police department. Brian, or Chief O'Malley, has not complained and said, we can't do this because I'm shorthanded. He actually, when we had the problems in Kennedy Park this summer, he found a way. He didn't like to have to do it. He didn't like to have to pull people from special projects to patrol the park, but he did it. And he did it with not a whole lot of complaining, at least not publicly. And his officers are overworked. I think you have some very good staff, and I'm sure they're overworked. But I think it comes to a point that you can't fall back on your heels and say, my staff is overworked and we can't get this stuff done. I want you to say, okay, we're going to try our best. Here are the numbers. And some of that transparency can eliminate a lot of the questioning, a lot of the anger in some areas. There's a number of people in this community who have lived here all their lives. I, for one, I chose to work here. It's very important that you understand people have a right to have some answers and not say we're overworked. I'm sure your ADAs do a very good job. You have some real good prosecutors. And I'm sure they are overworked. But so isn't everyone else in this community. So isn't the people at the jail. So isn't the police department. I am sure that if you were to get 3 positions in your office, you would probably have 25 or 30 applicants for those 3 positions. Chief O'Malley has not had that ability, nor has any other police department in the state of Maine had the ability to say, I have 3 openings and I have 30 people that want them. So I wish that you would take your word and follow through and say, this is what we're going to provide to the community, versus saying, well, we'll get to it. Criminal information and convictions are public information. And our local newspaper does a terrible job at providing that. They don't have the reporters like Mark LaFlamme or Chris Williams who follow the criminal arrests and trials as they did. But I think your office could do a better service to this community by your office providing that information.
Well, I agree we can do a better job of getting the information and including that data with the monthly reports. I would just say, I'm not saying we're overworked and we're not doing the best we can. I'm telling you, we are doing the best we can. And I don't think the perception reflects the reality. I think that if folks, I think one of the things I pointed out when we were at one of our meetings, Lisa Bogue, who was attending the meeting with us, had just received a conviction on a felony domestic violence assault, and I pointed out to you, you're not going to read about it in the paper tomorrow, and when you picked up the paper, it wasn't there. There are many trials that are occurring and work that's being done that isn't made available to the public, and I think to the point that if those statistics or more data is made available, it would reflect that. I agree with you wholeheartedly. But the one thing you can't walk away from thinking is that our folks are not working as hard and as diligent as they can. They're not just throwing up their hands and saying, we can't do this because it's too much work. They're doing everything they can, and they're being overwhelmed. That's what's happening.
Anyone else?
Good evening. My name is Jen Hogan. I'm the president and CEO at Community Credit Union. We're on 144 Pine Street in Lewiston. I appreciate the DA joining us this evening and giving this presentation. I can speak from experience that our credit union sees a lot of these issues on a regular basis. And we were certainly the first ones to always call the police department and say, come down and deal with our problem. And the police department has been wonderful. We have a great relationship with them. And if I can speak about human trafficking specifically, that's certainly an issue that we are presented with pretty much on a daily basis. And I called the police department and said, you're just not doing enough. And they said, you know, we've got some system constraints that we're working with. And I said, well, then connect me to the DA's office, and they did that. And I just want to note that in doing that, I've now been connected with the Human Trafficking Collaborative that Andrew spoke about briefly at the beginning of his presentation. And the credit union is really engaged in this conversation. We're working with many of the social service agencies and both the Lewiston Police Department and the DA's office on planning a community dialogue that's going to be specific in regards to human trafficking. And I have some flyers tonight if anybody's interested. It gives the community an opportunity to come. We're going to be sharing a case study to really talk about the experiences that individuals go through, the choices that they have, the choices that they don't have, and focusing on the system restraints that are involved in that, you know, what the DA's office can and cannot prosecute, what the Lewiston Police Department can and cannot do, and allow the community to really talk about how the community can get more engaged in the process instead of just, you know, asking the police department and the DA's office to do things that they legally can't do. So that information, it's December 20th. Being held right across the street at the Lewiston Public Library from 5 to 7 p.m. So please help us spread the word and join us if you'd like to be part of that dialogue. Thank you.
My name is Beth Matthews. I live on Bradley Street. And, you know, I appreciate that you stood up and spoke about what you're experiencing in front of the credit union. What's great about it for you is you get to go home at night. You're not living with it day in and day out. It's not affecting the lives of your children. And for everyone here that's an advocate, I realize that you have an important role to play in the human trafficking. But please understand, we are not asking them to be reprimanded. We want to have a healthy, safe community to raise children. It has nothing to do with how he prosecutes, who goes to jail. I don't care if you have a fine or not. I don't want you selling yourself in front of my house. And I don't want it affecting the property value. I don't want to go outside and find needles on my lawn. And it's very personal for us because we have a community that the entire state mocks, you know, calls names, and it's hard because I'm not proud, Andy. I'm not proud of my community, and I should be. I love my home, I love my family, and I can't provide for them the safety that I should be able to in a modern society. So although I know that you are overwhelmed, the police department is too, I don't want to continue talking about how we're going to pay for their you know, mental health and their addiction. I support universal health care, and I think this is probably a good way of opening that up. it doesn't mean that we want to see something, you know, there doesn't have to be a penalty for what they're doing, but they do need to get off the streets. There does need to be checks and balances, and we aren't enemies for calling the cops and expecting them to be held to the line. And as many of the advocates that are here, and I'm not sure who you are or who you're not, but we live here. If you don't and you're not experiencing it firsthand, it doesn't really confront me. So I appreciate the work that you do and the services that you are trying to set up for them if they take it. But if they're not saying, I'm a victim, I want them prosecuted. Thank you.
Anyone else? Okay, anything final from the council? All right, so Andy, thank you very much for coming. I know in the middle of our tough summer, you and I had a pretty rough phone call the first time around, but thank you for everything you've done since then, and you've done some community meetings, and the transparency is increasing. I think we still have some work to do there, and you brought this council in, and you've been here a couple times, so thank you very much, and we look forward to continuing to work with you and have you work with our PD and do what you can. Thank you very much.
Thank you.
And with that, we are done.